Hello everybody and welcome to this new Privacy Rules webinar episode. Today we are going to discuss about a very relevant and hot topic of the moment, that is the spread of the COVID-19 virus. And in particular we are going to speak about the way in which different Asian countries are facing and fighting against the virus, and in particular are controlling the use of data during this very difficult period. In order to do that, we have invited 5 of our Asian members. In particular, we have today with us Ruth Ng from Taylor Vinters Via in Singapore. We have José Leitão from MDME Lawyers in Macau. We have Hyunjee Kim from SEUM in South Korea, and we have Pádraig Walsh from Turner DeWitt in Hong Kong, and Akira Matsuda from Iwatagodo from Japan. So in order to better address the topic and without further delay, I would like to discuss about this topic with our Singapore member, asking her how Singapore is facing the virus, so which are the measures in place and which are the main effects of them.
So in Singapore right now, I think it's generally seen that the government is giving very clear directives on various fronts. On personal data, our Personal Data Protection Commission has already issued very clear statements saying that in this current scenario, you may collect, use, or disclose personal data without consent during this period to carry out contact tracing and also any other necessary responses to the outbreak. But they're also very clear that you need to have the reasonable security arrangements in place, and this can only be insofar as necessary in response to COVID-19. So they're very clear about the legal issues. I think also something I'd like to share is they're looking for other innovative solutions that will tackle the privacy issues in this time, such as coming up with an app called Trace Together, which I think is quite interesting. They basically, citizens are encouraged to download an app which will use Bluetooth technology to record encrypted information on whether you are in contact within a 2-meter radius with other users for more than 30 minutes. If anyone actually is diagnosed with COVID-19, they may request for access to their app to know who they've been in contact with the last 14 days, so that contact tracing can be carried out. So in this paradigm, location data is not collected, names are not actually accessed until a diagnosis is informed. That's how our government has been trying to tackle this issue.
Okay, thank you very much, Ruth. And Hyunjee, how South Korea government is facing. South Korea has been one of the most interesting countries to see also from the rest of the world. So we would be really interested to know more about what's happening and how it's going there.
Well, we had a huge outbreak in February, and especially it was hit hard in the city of Daegu. And as you all know, but even though the number of confirmed patients and the deaths have been plateauing a little bit, the government and the Control of Disease Center is all very cautious at the moment, and they are recommending that to not gather around, and they're also recommending not to operate pubs or training facilities or gyms at the moment, but they're not exactly enforceable, just recommendations at the stage until at least April 5th. And from a privacy perspective is that most of the patients, their information is public through the data, through whether the city or the provincial or any type of database, and their basic age and location and every place they have been can be made public. And the Control for Disease Center is working hard with the Ministry of Land and Infrastructure and Transport to collect these information via telecommunication service providers and credit card agencies as well. So that's one of the issues that we would be tackling.
Okay, thank you very much, Hyunjee. And Jose, in Macau, how the government and which are the main restrictions that are relevant on the topic? And do you also see some advantages on the way in which you are addressing the problem?
In Macau, I think from all the jurisdictions that are participating today, Macau fortunately was the least hard hit. We have a total of 26 confirmed cases, 16 active, and fortunately 0 casualties so far. That being said, the government has taken quite stringent rules and has implemented a number of restrictions, particularly regarding travel, and has created a self-declaration system that requires people coming in from Macau, at least until yesterday, when all entry was severely restricted due to the resurgence of cases in Macau and in Hong Kong. But there is a self-declaration system that the authorities use to gather the information about people, namely about symptoms, about their whereabouts over the past 14 days, etc. The government, of course, enjoys under the local data privacy laws, the government enjoys a wide array of exemptions, and it would be foreseeable that they would be using them at this point. The data privacy regulator, the Data Protection Office, has not yet come out with specific guidelines on how private entities should be managing this, which means that basically the general provisions of the law remain intact and have not been exempted in any way. And this is particularly relevant because a lot of the information that will be collected and that is being collected right now is in fact under our law sensitive data and normally would be subject to prior authorization from the regulator. I think the practical perspective right now is that the regulator, it's not on the forefront of the priorities of the regulator to enforce this, but, and we'll touch base on that a bit further, I think we all have to understand that even though the effects will dwindle and the number of cases will for sure go down, we have to be prepared for the fact that this might be a new normal and that entities will have to collect health data from their employees and even from their clients in certain cases with more regularity. So there will be a time, I think, soon when companies and private individuals will have to take care and comply with these provisions.
Okay, thank you very much, José. Yes, that's right. That's a very good point. Interesting. This is definitely the first, probably the first virus that spread in a period in which the use of data really started to be, really at a worldwide level and really big. It's huge. So, Pádraig, what do you think about that, and what Hong Kong is doing to contrast this COVID-19?
What's interesting in Hong Kong, I guess, is that maybe different from other locations. There's a bit of embedded history with viruses of this nature because we have gone through SARS, as indeed, Macau would certainly well remember that, as would people in mainland China back in 2002, 2003, that era. So within the society, there's almost an embedded knowledge of how they should behave. It isn't something that had to be necessarily learned or acquired as maybe more the case in the EU or in North America. But, focusing on the personal data privacy aspects, I guess if you're to look at it at a conceptual level, one of the interesting things is that it does highlight that personal data protection is not an absolute right. And this is something that has been repeated and reiterated by the Privacy Commissioner and by legislators. And it's interesting to see in that context the provisions within existing laws that have been relied upon to enable the public health issues to be properly addressed. So there is a permission to use personal data in circumstances where a failure to do so would cause psychological or physical harm to others, even if it is not for, that personal data is not for the original purpose for which it was collected or consented. And that's been relied on, particularly in the situation where you're looking at, say, employers looking to make notifications about, their employees. And then, there is an ordinance around the prevention of and control of infectious diseases and COVID-19. There was a class of diseases added as a scheduled disease that included, was broad enough to include COVID-19. And that allowed the mandatory reporting obligations of medical officers and doctors, as well as the compulsory quarantine provisions and location data surveillance and other things that go with that to come in force and to be to be complied with. But allied with that, the Privacy Commissioner has also still adhered to reminding people of other principles, like the principle of proportionality, so that you try and choose the least privacy intrusive measure in order to gain the information that's required, and you still are only obtaining the data that's necessary for the purpose for which you're collecting it, as well as reminding people of principles around the security of maintaining that data, and that the data should only be retained for as long as it is needed. So hopefully we will see a day where COVID-19, there'll be a vaccine for it or whatever it may be, and it is no longer as pressing an issue as it presently is. Then people should be mindful of what they do with the data they presently hold and whether they still need to retain it.
Definitely, Pádraig. We really hope to reach that moment really soon, I think. And yes, and Akira, to you, what about Japan? What's happening there? We know that your authority didn't publicize anything in relation to data privacy, but is there anything that you would like to raise?
In Japan, we do have almost 1,000 confirmed cases, and compared to the population of 120 million here, this number is a bit slower than the most rapidly outbreaking countries. However, the government has decided to postpone the 2020 Olympics that was originally scheduled to be held this summer, at least 1 year, but the timing is not fixed yet. As Alessandro mentioned, Japanese DPA hasn't issued any public announcement or release as to treatment of the personal data under this situation, which means that any COVID-19 related personal data should be handled in accordance with the basic principles under Japanese personal data regulation as usual, which means we do have a consent-based regime, and the fact that the person is infected to COVID-19 or related information, in most of the cases that will fall under the sensitive personal data. So for collection and third-party transfer of such information requires consent of the data subject. There are two exemptions to that consent-based scheme, and the first is whether there is when it is necessary for protection of life, body, or assets, the business can transfer such data without consent of the data subject. And the second exemption is where necessary for public health and welfare. In most of the cases, businesses are trying to obtain consent from the data subjects, including the employees. But in some cases, they must decide whether they can rely on exemption on collection or transfer of the information. And we do receive many requests from our clients on these kind of questions right now.
Okay, thank you very much, Akira. Thank you very much, you all, for this very quick set of answers. Akira, I would like to continue with you with the next question. I think we can move on, which are the main problem for corporations and companies due to the fact due to the spread of the virus, and like in Japan, what companies have to do, for example, in the use of employee data.
The most difficult question that the companies face is, once there is a person who is infected to the coronavirus within their corporation, how should they disseminate such information internally or externally? So for internally, if a person from one department got infected, what kind of information they should share internally within their corporation? From a privacy perspective, such sharing of information should be kept to minimum. So for example, if one person got infected in one of the floor or one of the department, if they do not need to disclose the exact name of such employee, then the company should not disclose the name of the person who got infected, but only the fact that the person in which department got infected internally. The same for a company to disseminate such information externally. So for example, if they are to decide whether or not to provide such information that someone got infected in such corporation to a management company of the building, then they should negotiate very well with the building management to minimize what information they should provide to the building management company. This privacy issue is sometimes a bit tough issue for the companies to decide, because the external parties such as the building management in many cases requires as much information as they want. And the company have to negotiate to minimize what information they provide to the building management company.
Okay, thank you, Akira. And Pádraig, to you, what are the top priority for companies in Hong Kong in relation to what's happening?
So a lot of the issues that have arisen in Hong Kong have focused more in relation to HR type issues, rather than necessarily personal data and privacy issues. One of the things, maybe just to take up on a point that Akira was speaking of, and it just shows how you can get into gray areas. To a certain extent, if you have a situation where there is a suspected case within your own workforce, that has a certain level of response. But given the nature of the virus and the fact that the degrees of connection can be somewhat remote, there's also issues that arise at a management level where a person who may have visited the premises is subsequently found to have been diagnosed as a case of COVID-19. But because they have visited your premises and interacted with people, there's an issue about how you should deal with that in terms of disclosure. In general, the advice we've given in those situations is that those whom you can trace as having direct engagement or contact with the person who was on your premises, you disclose that fact to them, and you take steps in order to make sure, as an employer also, that they are safe and looked after. But would not necessarily be a case where you would broadcast and disseminate that broadly otherwise within the firm. You are trying to contain use the information you have proportionately, but also with a view to protecting the health and welfare of people who are working with you. The other employment type issues that arise are naturally around health, welfare issues, and whether you adopt health screening on a mandatory basis or on a self-reporting basis, those types of issues. On the downside, in terms of how long this may be going, and particularly in some industries that are more public-facing, like retail, F&B, there are also redundancy and layoff issues that are arising.
Okay, perfect. Thank you very much, Pádraig and José. I was thinking also for Macau, and which are the main issues related to companies in Macau. I don't know if there are also other business effects related to that.
I think the main issues are a bit of a combination of what Akira and Pádraig raised. The issue of how this information can be treated, because under local law, like I said previously, this is sensitive data, so it's subject to authorization from the regulator for treatment. And I think that's going to have a particular emphasis on the HR side of things, because employers will legitimately scrutinize more the whereabouts of their employees, the symptoms that they may have. A lot of HR processing is done cross-border, namely in Hong Kong, which is the regional center for a lot of businesses operating here in Macau. So there's also an issue of transfer. And by and large, the majority of companies that collect, treat, and transfer employee data, their notifications and the disclosures that they have made to the regulator do not encompass health data or sensitive data. because it's not a natural part, or it was not a natural part of the type of data that they would be collecting from their employees. And I think the main issue is companies will have to comply with this, so they will have to apply for authorization at some point. And like I said, I think we're going to see a shift in the paradigm, in the sense that this is going to be more and more a normal part of information that employers collect from their employees, and so I think that a compliance effort from those companies will necessarily need to be made towards that.
Thank you, José. Yes, definitely. What's happening now is going to affect the way in which companies are using data also for the future, and that's something that is happening probably at international level. I think that's something that came out from many of your colleagues inside the PrivacyRules Worldwide Alliance. And Hyunjee, what about South Korea in relation to this point?
Same issue here as well, but the privacy and personal issues are not the top priority at the moment, because people are more worried about whether the disclosure of the correct information and the dissemination of correct information, rather than the personal information of one person. So but it's not exactly up to the employer to disclose, because once you have you are a confirmed patient of the COVID-19, then the government, using its very centralized authority, can trace you everywhere you went, including your the place where you work. So in that sense, not the company's name itself, but the location of where your company is, if your company will be disclosed on many websites that are publicly available. But actually, one of the more pressing issues was it's not related to exactly privacy issues, but more related to business, is that because most of the fiscal year ends at December 31st in Korea, we have to hold a ordinary general meeting of the shareholders by March 31st. So everyone has been pushing that back as far as they can, but they have to hold it within this month. So rather than the privacy issues, one of the most general questions we have received is whether they can hold it electronically, which is kind of ironic, because while the board of meetings can be held in conference calls and video conferences such as this, most of the general meeting of the shareholders is you have to either attend yourself or through a proxy, or if there is any articles of incorporations or sections where they provide otherwise, you may do it by confirmation of letter, but it's not really possible to do it electronically. So it's been difficult disseminating to provide the good advice to the clients who are pressed to hold their meetings. So it's not a privacy issue, but it's been an interesting issue that we have not been dealt with.
Okay, perfect. Thank you very much, Hyunjee. And Ruth, you are the last one of this round of questions. Which are your consideration, and which are the main problems to be faced in Singapore? Are the same of your colleagues, or there are some differences? What do you think?
I think similar to Hyunjee, privacy is not one of the top concerns right now. I think the government and also organizations have done a very good job establishing trust in the community that personal data is not being abused. One of the main differences, I think, compared to the other countries might be that names and personal data are not released in the news or in announcements. So if people are being announced as having diagnosed, or if a person in the office building has been diagnosed with COVID-19, his name won't be announced. They'll just say give general information, and only if you were in close contact with the person will you be contacted directly. So that goes a long way in reducing problems in this area. But what we see have become top concerns of businesses here are, I would say, three things. One, manpower and employment, as with many other countries. Two, real estate and leasing issues. And three, imports. As a city-state, we rely very heavily on foreign manpower and imports, and also our leases here are very expensive. So when I speak to my counterparts in other firms, one of the most common things that come up right now is whether they can ask for rental rebates or if they can default on their leases. And that's a very common issue right now in Singapore. And there's a lot of controversy on whether landlords are giving out enough support to their tenants. On the manpower and employment front, there has been a lot of directives on not legally, not with legal force, but there have been a lot of directives from different ministries on how employees should stay in Singapore. Can they come in? Can they go out? Especially across the causeway in Malaysia. And there isn't that much hard law on it, but there's a lot of directives and also a lot of government support on this matter. On the import front, we are seeing an increasing problem there as food supply, food security is now becoming an issue in Singapore. I mean, the government is trying their best to stop any panic by saying that we have enough food resources for the next 3 months and trying to negotiate food passage across the causeway and whatnot. But these are things that are increasingly becoming a cause of concern for many businesses.
Okay, thank you very much, Ruth. And I would like to ask very briefly to each of you if there is any advice that you would like to give to the companies of your countries. So for each of you, what companies should bear in mind, in particular, if they want to collect or use of data in relation to this situation. Ruth, I would like to start with you and move back to your colleagues now.
Okay. For personal data, I think, as Pádraig has and many of my other counterparts here have pointed out, proportionality is very important. There are a lot of precedents out there given out by the government as to what you should collect, what you should disclose. Be familiar with that. If you're not sure, please come and always contact me, and I can give you some guidance on that. And other things to take notice, you might want to take a closer look at the force majeure clauses in your contracts. And if you need guidance on that, we are always happy to help as well.
Okay, thank you very much, Ruth. And Hyunjee, which are your main advice to companies in South Korea in relation to this situation, and what SEUM can do to help them?
Very new type of concern for every company. So rather than jumping into anything, any new territory that they're not used to, we always advise the companies to always contact their lawyers before making any critical decisions regarding HR matters or privacy issues, etc. Because we don't want to rush them or pressure, let them feel like they're pressured into a situation where they might be not complying with any different and juggling different laws while dealing with this new type of stressful situation. So one of the things that we want to make sure ensures that, because the labor laws, the HR issues are especially strict in Korea and very worker friendly. So that's one issue that we need to tackle. And as for privacy, while the public is still encouraged to make everything available, we just want to make sure that when the retainment period for all this privacy information will be concluded. It says because they said that the Korean Center for Disease Control says that they will retain this information and destroy as soon as the situation is over. But since we do not know when the situation is over and how that will be defined in the future, that's one of our concerns. But that's something that we need to work together to work out, and hope we can advise as well.
Okay, perfect. Thank you very much, Hyunjee. And José, what about in Macau? What MDME lawyers can do to assist companies in relation to the situation, and what's your main advice to them?
As a response to this situation, and given the growing number of inquiries from our clients, we've been putting together, and it's going to come online very soon. We've been putting together a COVID-19 resource center. It's basically going to aggregate all official information with the measures that are being taken. It's going to consolidate some legal alerts on issues such as force majeure, performance of contracts, HR, etc. It's something sort of all things COVID-19 for our clients to be able to sort of that and at least get a general idea of where they stand. In terms of advice, I think that HR right now needs to be taken very seriously. I think critical decisions, really need to be thought and well thought before being implemented. On the data privacy side, I think that there has to be a lot of attention to not only proportionality, in my opinion, but also accuracy. This is a new situation. The ramifications of this situation cannot be seen right now. And a lot of things can happen to someone who is reported as being suspected of having been infected or as being confirmed as having been infected. And if that information is not processed carefully, is not processed according to the law, and is not disseminated very carefully, Macau law provides for a right of indemnification in cases of abusive usage of personal data. So I think companies should definitely move sooner rather than later towards regularizing their situation with the regulator and making all the requisite notifications. And on a final note, I think that there is going to be a lot of the world is not going to stop. And Hyunjee was raising something that is quite relevant, which is here in Macau, there is also a legal obligation to hold a general shareholders meeting and approve the accounts for the previous fiscal year until March 31st. And a lot of companies will not be able to hold these meetings, but these meetings have to be held anyway, not only because it's a legal requisite, but also because the accounts have to be approved for tax purposes, for internal compliance purposes, for group purposes, for shareholder dividend distribution purposes. And so I think that companies should also consult with their lawyers to see in what ways those general meetings can be held and how they can try to circumvent these restrictions and still meet their corporate compliance obligations.
Okay, those are all very good points, Jose. Thank you very much. And Pádraig, what about in Hong Kong and Tanner DeWitt?
Actually, building on just Jose's last point, and given the breadth and range of topics we've already covered in this conversation, it's probably worthwhile to pause and think about the kind of legal services and support that will be needed as things go forward from here. If this is a new normal, and if you pardon a fluvial metaphor, also a fluid situation, we know that we're going to have to be agile in terms of the advice and the help and support we give to our clients. And you can see that some of the situations that are going to arise in the weeks and months ahead might well be novel situations where we'll have to apply existing law rules and frameworks to try and help people to make business be as normal and as practical as possible. Some of the things you can see arising in that situation are where people are working in remote or from home situations, where you have contracts and other business arrangements that are being arranged digitally and electronically as opposed to in person, and the kinds of risks that arise around that. So I can see advice being needed in situations where people are doing completions on transactions, and that all needs to be done remotely through e-signatures rather than your nice formal traditional corporate completion meetings, and there'll be advice around that. You can see that there will be advice around maybe cybersecurity issues that will arise, because if you have people working from home and in remote environments, they don't necessarily have the full array of the IT infrastructure that might apply if you're coming to an office with an IT department that has IT protocols and policies in place for the environment you're working in. And you can see certain IT risks that will arise from that need to be managed, addressed, and legal advice will be needed on. So there will be other topics that will arise that we as lawyers just need to be agile to and be able to respond to. It's an evolving situation.
Yes, thank you very much, Pádraig. That's a very interesting series of points, in particular the new one that you just bring about the cybersecurity issues related to people working from home. Not necessarily everyone has the means and the instruments to protect his data when working from home. And it's going to be interesting to see eventually who's going to be liable if anything happened. And finally, Akira, what from the Japanese perspective?
I might touch upon 3 points, somewhat related to the topics already covered. But as to the contractual arrangement issues here in Japan, still sometimes makes a difficulty or complication in the interpretation of the contractual obligations, because our government has not announced that this is an emergency situation, or when they ask to cancel large events or events that may disseminate the virus, it is always based on the non-binding request basis. So in case the business decide to cancel some event or make some decision, this is based on their business judgment without the binding request or order from the government. This situation may change, but currently this makes the complication when we advise as to the contractual arrangement. And in terms of HR, as you may know, the same in Korea, South Korea, that termination of the employment in Japan is very strict, especially when it is caused by the redundancy. And at least at this moment, this theory or principle has not been changed in Japan, so that when this situation continues, that the corporates might have a tough decision on whether to terminate the employment or not in the long run. The third point, many of my colleagues have touched on the annual shareholders meeting. Situation is the same in Japan. Most of the Japanese corporations have a fiscal year end of March 31st. This means that the general shareholders meeting must be held before the end of June this year. Because of the spread of the coronavirus, it is a tough decision on how to manage and operate the general shareholders meeting, because we cannot hold it virtually. So that means the company must set a place for such meeting and actually hold a meeting. And the businesses are now starting discussion on how to manage the situation, although they are actually holding the meeting at an actual day.
Thank you very much, Akira. And I think we ran out of our time. I would like to thank you all very much for joining us today and for all your perspective. I think there are many different points that have been discussed and addressed in relation to the risks and the problem related to the coronavirus. And that's why PrivacyRules is creating a team of experts to provide advice and help companies at a worldwide level to better address the problems related to the coronavirus. So I would like to thank also our audience for joining us today, for listening to us, and I hope to meet all of you very, very soon again. Thank you very much.